So this is attorney Shakina Melbourne, and I wanted to do a little video about evictions. Our law firm practices evictions, and we get a lot of calls, checks from our emails and our website about how can you help with a landlord-tenant case. Well, we primarily help landlords, and that is our primary client. But one of the biggest things that we're discovering is that people don't truly understand the differences between the two types of landlord eviction cases that exist in the state of Michigan. So one is non-payment of rent, and the second one is recovery of possession. In this video, we're going to talk more about the process as it relates to a non-payment of rent case, okay? All right, so with a non-payment of rent case, here's what the deal. The tenant owes you money, ironically, and you're trying to figure out, are you going to give them an opportunity to pay those funds and stay in the property? Or are you going to say, well, here's the deal. If you don't pay, you're going to have to move. Most people don't understand this logic because whenever you're going into an eviction, it's usually because the person hasn't paid, right? Ironically. With these new rules and regulations that have stemmed from the COVID-19 and the time frame in the pandemic, there's some new changes that have taken place that are required when you do decide to do a non-payment of rent case. So one, when you're looking at a non-payment of rent, you're looking at, am I going to give the tenant an opportunity to pay the balance that's owed? If you are, then you're going to do a non-payment of rent. And that starts with a demand letter or a notice to quit that gives the tenant 7 days to pay, or an eviction case will be filed. Now, what does the word eviction mean? Eviction means a real estate legal action that's typically done in district court. And the district that is selected is the city in which the property is located. So if I own a property in Detroit and I have a tenant that needs to pay or they're going to get out, we are going to file that case in 36th District Court. So starting step one is filing our notice to quit with a 7-day demand. Now, that notice to quit can be found online, or if you decide to hire us, we can do that, okay? And so after the notice to quit is put together, it is then mailed out to the tenant, and we have at least 7 days before we can do anything. Now, the law actually says because the U.S. Postal Service can have their own delays, we cannot technically file any paperwork with the court until 10 days after the day the notice to quit is mailed out to the tenant. Okay? So that's step one, notice to quit. Step two, we give the tenant 10 days. You see what I'm saying? And they don't do nothing. They don't pay, and they don't look like they packing up. So our next step would be to file a summons and complaint with the court. And in my example, it would be in the court in 36th District because the property is located in Detroit. The summons and complaint must both say non-payment of rent. They must all go together. Fees are paid. The court is going to assign a judge, give us a case number, and the tenant must be personally served. But before that, meaning before the tenant is personally served, one of the things that 36th District has started is that it is now requiring the property owner must provide a copy of the deed to the property showing their ownership interest, and it likely and should be, if this tenant exists in the property, there should be a lease and an active lease attached to the property. This is, of course, how we know how much the tenant is paying every month and how much they failed to pay when we decide to file the case, right? So we can either give the court, at the time we're filing the summons and complaint, a copy of the lease agreement and the deed, or the court will give us an opportunity to file that before our court hearing, okay? We will then have the court officer personally serve the tenant, meaning you've been served. And then we'll have our first court hearing. Some courts have one court hearing and that's it. And then some courts will have 2 court hearings. Detroit is one of the few courts that still have 2 court hearings because they give an opportunity to the tenants to have a court-appointed attorney assist them and see if they have any legal rights. So, our first court hearing in Detroit is by Zoom. And at that point, as the landlord, you will simply be getting a new court date to come back. For the tenant will get an opportunity to speak with a court-appointed attorney at that first court hearing. Okay, so then we move on to our second court hearing. At our second court hearing, that's usually done in person, and that is where the judge will then be able to hear what is actually going on in the case. The love and hate in a landlord-tenant case were a non-payment of rent. If there is issues with your property, so now you're gonna get the other side. If your ceiling falling down, the roof taking place, cabinets ain't working, toilets ain't draining, basement is flooding, they're gonna use all that against you at that second court hearing. That one's called a repair order. And then the judge gonna say, you need to make all these repairs before I can make a ruling in your favor. So if you have issues making these repairs, you may consider or reconsider the idea of filing a non-payment of rent case, because all those repairs must be done before you will collect $1 from that tenant. Okay? The other alternative that could happen with a non-payment of rent case at that second court hearing, the job of the court-appointed attorney, believe it or not, is to figure out what rights the tenant has, not you, the landlord. So, if they see any discrepancies on the lease, because something's wrong with the way your lease was drafted and put together, they're going to use that to dismiss the case. If they think that there's an issue with your notice of quit, at the beginning, that 7-day demand, they're going to use that to try to dismiss the case. They may even say, you know what, this tenant need help. And so we contacted MISHTA and a rental assistance program. And so because they applied, usually on the day that we in court, because they applied, we have to get a new court date. And you got to come back in 2 to 3 to 4 to 5 weeks, depending on the judge's schedule, to come back to see if they got denied or approved for a partial payment to the balance owed. And you still got to hope that the tenant is able to pay the balance if there's a balance due. And so usually a landlord says, well, I did the 7-day demand in hopes that I'm going to get my property back sooner. In fact, it actually takes longer. And if it doesn't take longer because an adjournment, new court date, adjournment, the adjournment didn't take place, or you didn't have to come back because you had to make repairs to the property, and that took another 3, 4, 5, 6 weeks before you can fix it. Or it's because, I forgot to tell you, starting in November, BSEED, that is Building and Safety, is now going to be coming into the courthouse to confirm you're making these repairs to the property. Your property has been properly inspected. You have the correct and necessary certificates of occupancy. Don't judge me. Okay. Occupancy on your property at the time you go in there, because you said you want your money. And if you don't have your certificate of occupancy, if you don't have all your repairs together, if you know at the time you're trying to get this person out your property, all your stuff ain't together, please do not file a non-payment of rent case. Please, I beg you. Just please, just know you're going to take the loss on the income and you just going to get your property back. And if that's you, I need you to watch my next video on how to evict a tenant for recovery of possession. No money, just move out. Give me my property back. stay tuned to the next one.